Prayers.
Almighty God, who in thy wisdom and goodness has appointed the offices of rulers and parliament for the welfare of society and just government of men, we beseech thee to behold with thy abundant favor us, thy servants, whom thou hast been pleased to call to the performance of important trusts in this land. Let thy blessing descend upon us here in this house assembled. Grant us that we may treat and consider all matters that shall come under our deliberation in so just and faithful a manner to promote thy honor and glory, to advance the peace, prosperity, and welfare of this country and of those whose interests thou hast committed to our charge. Amen.
Correction and approval of the records of votes and proceedings of the National Assembly sitting of Friday, 6 December 2020.
Honorable members, the record of votes and proceedings of the National Assembly sitting of Friday, 6th December 2024 is before us for correction and approval. Can any honorable member please move that the said record of votes and proceedings be considered and approved? Honorable member for Sabak Sanjal.
Thank you very much, Honorable Speaker. I rise to move that the records of votes and proceedings of the National Assembly sitting of Friday, 6th December 2024 be corrected and approved. Thank you.
Thank you, Honorable Member for Sabak Sanjal. Any secondary honorable members? Honorable Member for Nyanija.
Honorable Speaker, I rise to second the motion.
It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of 6th December 2024 be considered and approved. Honorable members, we all have copies of the said record of votes and proceedings. And as usual, we look through it page by page and then invite observations and comments, beginning with page 1. Honorable Member for Jara Central.
Thank you very much, Honorable Speaker. Honorable Speaker, on page 1, the first caption on top, the headings there, record of votes and proceeding. We should add S to that. To proceeding. Yes, exactly.
That's honorable members, the heading on top. Sixth Assembly of the Republic of the Gambia, then you have record of votes and proceedings.
And Honorable Speaker, wherever it appears, because it appears on other pages too.
Very much, and wherever it appears. Thank you.
Honorable Speaker, to continue on the rectification, on Roman number 2, just below time allotted, Minister's reply to report, we should add the Article D. We should insert Article D between to and report, and wherever it appears.
About item 3, number 3. Number 3, Roman 2. You have minister's reply to report, to the report, THE, the Article D, and wherever it appears. Yes, any more? You are any more on page 1? Honorable Member for Jara Central.
Page 1, the first line, the assembly convened at 58 minutes after 10 o'clock. The word "at" is missing.
Hello? Yes? The assembly convened at. Thank you, Honorable Member for Jara Central. Any more on page 1? Honorable members, we move to page 2. Honorable members, the time allotted is one hour, not 1 hour. Any more on page 2? We move to page 3. Honorable members, we can move to page 4. Honorable members, we move to page 5. Page 5, Honorable Member for Wool East.
Thank you very much, Honorable Speaker. Honorable Speaker, on the second paragraph, line 2, where it says, raise a point of order on the SO 102 and arguing. So I suggest that we remove the "and" It just continue arguing that the Honorable Minister, then it goes. You've seen it. Saying, yeah, just chatting there. It's not.
Any more?
Yes, the next paragraph to that, the first line, at this juncture, the Honorable Speaker uphold. So I suggest we change it to upheld. It's in the past.
Please put up your mic. The third paragraph, at this juncture, comma, the Honorable Speaker upheld, not uphold. Any more, Honorable Member?
The same paragraph, the third line, where it says, Honorable Minister, it says to decide on whether to permit the Honorable Minister to deliver. The to is missing. It should be to deliver. And then we remove the ed there, between minister and deliver. And then we remove the ed on the delivered. It's delivered, just deliver, not delivered. And yeah, okay.
Just after the corrections, delivered his response. The S should be responses. The S should be out. Yes, continue.
Deliver or to defer. So we remove the ed on the defer. Or the red, the red.
RED should be out. Any Honorable, any more?
Assembly permitted the Honorable Minister to deliver his statement. There too, it's in the present tense, not in the past. We remove the ed on deliver.
Abstained. Sorry. What am I? Yeah, delivered. Yes. Any more?
Yes, and the last paragraph, second line, it says, which were answered by the Honorable Ministers. Then he said in his reply. So since there are two, it should be in their replies to the report.
Questions which were replied by the Honorable, which were answered by the Honorable Ministers. On there. Answered by the Honorable Ministers in their replies. IN for on, THEIR for his, their REPLIES for reply. Any more on page 5? Honorable Member for Sami.
Thank you very much, Honorable Speaker. On top, time allocated to 1 hour, not 1 hours, wherever it is, applicable.
Okay. 1 hour is not 1 hours. Thank you very much, Honorable Member for Same. Any more on page 5? We move to page 6, Honorable Members. Honorable Member for Bakau.
Thank you very much, Honorable Speaker. Honorable Speaker, my name is not included in the list of members who ask questions, and I was part of the members who engaged the Honorable Minister on questions.
I think this is on information, isn't it?
Yes, this one is on information. What's the other one? The report. It was information and portrait. What replied to the report. It was
So, Honorable Member, you participated in the debate, and your name is not captured. Honorable Members, number 9. We add number 9, Honorable Hassan Toure. Member for Bakau. Any more? Honorable Member for Lower Salum.
Thank you, Honorable Speaker. Honorable Speaker, can we add this, at the invitation of the Honorable Speaker, the Honorable Minister for Agriculture, Life and Food Security gave his reply on the report of the committees and a Chinese written statement.
Honorable. More on page 6. Honorable members, we now move to page 7. As usual, time allotted, we remove the S 1 hour, and usually don't forget to put the proceedings on top of the page. Honorable Member for Nyamina West.
Thank you, Speaker. Well, I have also asked a question to the Minister of Agriculture, but I haven't seen my name on the list of those who asked. Thank you.
Page 7. What happened? Which one of the report of the response of the Honorable Minister? The last one. Probably the number 6 may be your name. Pardon? Where Muntolam? Honorable members, number 6, in fact, probably they want to put Birom, so was omitted, Nyamina West. Any more on page 7? Honorable members, we now move to page 8. Honorable member for Sabak Sanjal.
Thank you very much, Honorable Speaker. On page 8, motion 53C. If I may read, it says, at the invitation of Honorable Speaker, the Article D is missing there, and Honorable Kebalang Fofana, nominated member, move a motion for the said bill to adjourn the debate of the second reading. I believe that should read as Honorable Kebalang Fofana, nominated member, moved a motion to suspend the debate on the second reading of the bill, and it was seconded by Honorable Alma Mejiba, member for Fonyi Kansala.
Honorable members, are you following? Because what is there does not move a motion for the said bill to adjourn. What about move a motion, you remove the said bill, move the motion to adjourn the debate of the second reading of the bill. Yes. So we remove for the said bill, we remove it. Move a motion to adjourn the debate on the second reading, not of. On the second reading of the bill, and it was seconded by Honorable Alma Mejiba, member for Fonyi Kansala. Is that okay? Okay. Any more on page 8? Honorable member for Sani Mentoring.
Thank you, Honorable Speaker. On time allotted is 1 hour. The second paragraph under that, where you have Honorable Alaji Mbo, member for Upper Salem, seconded the motion and participated in the debate instead of on the debate. Thank you.
Honorable member, you've seen it. Yes, participated in the debate. Thank you, Honorable member for Sani Mentoring. Any more on page 8? Honorable member for Jara Central.
Thank you, Honorable Speaker. On page 8, order 67, the line below that, Roman number 1. By honorable information. So we should insert Minister for. The 2 words, Minister for information.
Members, you've seen it. On top of page 8, where you have second reading, by Information Media and Broadcasting Services, is by the Honorable Minister for Information Media and Broadcasting Services. Thank you, Honorable Member for Jara Central. Any more on page 8? The last page, page 9. Honorable members, it has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Friday, 6 December 2024 be approved with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, may we proceed?
Correction and approval of records of votes and proceedings of the National Assembly sitting of Saturday, 7 December 2024.
Honorable members, the record of votes and proceedings of the National Assembly sitting of Saturday, 7th December 2024 is before us for correction and approval. Can any honorable member please move that the said record of votes and proceedings be considered and approved? Honorable member for Yara West.
Thank you, Honorable Speaker. I rise to move that the record of votes and proceedings of the National Assembly sittings of Saturday, 7 December 2024 be considered for correction and approval. Thank you.
Seconder, honorable members. Honorable member for Sani Mentoring.
Thank you, Honorable Speaker. I rise to second the motion.
It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Saturday, 7th December 2024 be considered and approved. Honorable members, we all have copies of the said record of votes and proceedings, and as usual, we will look through it page by page, beginning with page 1, and invite your comments. Honorable member for Woolly East.
Yes, thank you. Just a little one. The same convene at is still missing. And then, yes, at the top.
Continue.
I see Honorable S. Dabo there, but I think he was absent on that day. Minority Leader, Brikama North.
Where did they get the name? Full members, we remove number 3, renumber it, and then put number 3 at the last one. $59, huh? Do you follow? Are you following? We remove number 3 on page 2, that's Honorable Alaji S. Dabo. We renumber it, 1, 2, the 4 becomes 3 now and continues. And then you go to those absent with permission. We continues on page 3. You add Honorable Alaji S. Dabo. Thank you very much. Any We move to page 2. Honorable members, our earlier correction, where we removed Alaji S. Dabo, and we said we put him at 59. No, we will put him at 40, under the following members were absent with permission. Just before Bileji Tunkara, you have number 40, Alaji S. Dabo. Are you following? If you renumber those ones, 40 becomes 39. You understand? And then the 40 now goes to down just before Honorable Bileji Tunkara, and we put Alhaji S. Dabo, Honorable Alhaji S. Dabo. Member for Bikama Central, Bikama North, and minority leader. So the proposed correction on page 3, where we talked about 59, there should be no 59 because we don't have 59 members. Should be deleted. Honorable members, any question on page 2? Yes, please. Honorable Central, Gara Central.
Honorable Speaker, this one is a small one. The following members were absent with permission. As it is a period there, full stop, but it should be a colon. Thank you.
Thank you. Honorable members, we move to page 3. Honorable member for Serekunda.
Yes. My name appears on people, members absent with permission. I was here on Saturday. Yes.
Honorable members, 52 be removed. Honorable Musa Cham for Serekunda. It makes our whole thing funny again. What probably, honorable members, we can do is put Musa Cham 41 under those present and then move Alagi S. Dabo to Musa Cham. Am I right? That will prevent us from renumbering and then changing again. Honorable Musa Kiam. Serekunda. Would that king? Does not claim leadership and does not give, even if you put your name first, it doesn't mean you are the leader.
What I mean, normally they do arrange it based on the leadership.
Yes, may I hear your point of order?
Thank you, Honorable Speaker. You know, what I mean is normally they make this arrangement based on the Honorable Speaker, what I mean, normally they arrange these things based on the leadership. Like Honorable Fawaga Tombonjara, Honorable Sidi Njai, Honorable Alaj S. Dabo, Honorable Ablai Sise, Honorable Madi Sise, then you have the ordinary members follow suit. So,
we ask the table office in their final draft, let them rearrange it properly and number them properly. Is that okay? Okay. Yes?
Where he should be placed is in the area of permission, not the members that were present. Alaji S. Dabo. So where are you going to? It's in the absent list.
That's where he is going to 52 on our own records here. But to make it easy, the table office now, in redoing the draft for the final print, they will arrange it in order. The following members were absent with permission. They will say Honorable Bileji Tunkara, then Honorable Alaji S. Dabo, and continue. Huh? Are we on the same wavelength? Okay. Thank you very much, Honorable Member for Busumbala. Honorable members, we now move to page 3. Sorry, we are on page 3. Yeah. Gara West.
just under the members absent with permission, number 1, correction and approval of, between off and record, the article D is missing. Correction and approval of the record of votes. Article D is missing.
Honorable members, have you seen it? He's making reference to number 1, the heading there. Correction and approval of the record of votes and proceedings. Have you seen it? Okay. Any more observations or comments on page 3? All right, honorable members, we now move to page 4. Honorable Member for Kiang West.
Honorable Speaker, after the motion, with the permission of the Honorable Speaker, Honorable Abdullah Sise, move the motion for the committal of this said motion to be referred to a Public Appointments Committee. However, in the process, Honorable Speaker, Deputy Speaker, on the chair at the time, when putting the question, suggested that the motion be referred to the Assembly Business Committee for referral, for committal to the relevant committee. But instead, this was the motion Honorable moved. But in the process, what transpired is that the Honorable Speaker suggested that the motion be referred to Assembly Business Committee for committal to any relevant committee.
I'm made to understand that usually bills are referred to the ABC for committal automatically for committal to the relevant committees. But this was a motion. It can be moved and committed to a given committee.
Honorable Speaker, what I'm saying is, this was the motion, what is captured on the report here present. But when putting the question, when Honorable Speaker was putting the question, he put the question for the bill to be referred to Assembly Business Committee for committal to a relevant committee. But this was the motion.
Given, tabled. Now, what I'm saying is, if a motion is moved, if a motion is moved, Honorable, if a motion is moved by somebody, all what I need to do is to make reference to that motion. If I do otherwise, it's an error. It's just a mistake. Yes, Honorable Member for Olyundum and Deputy Majority Leader.
Thank you, Honorable Speaker. I think what the member is saying, in fact, he's referring that the Deputy Speaker was on the chair as the Speaker. You were on the chair when I was moving the motion. Yes, it was Speaker who was on the chair. And the motion that I raised was for us to commit the motion to the Public Appointments Committee directly. That's what I said. It was not Deputy Speaker on the chair.
I think I was the one sitting, not the Deputy Speaker. I think probably you may be thinking, you may be associating two different things. Honorable Member for Kiang. Any more questions on page 4? Honorable members, we move to page 5. If you look at 9, number 9 on page 5, question put and agreed to that clauses 170 and 171. Therefore, it is more than one question. Do you follow me? Am I right? For the two clauses, one question was put. No, how can I put, we are going clause by clause. How can we put two clauses together to put a question? Yes?
And say wherever it is. Yeah.
"13 is an order, and 14 is an order. You said we pass orders. No, number 3 is questions, it's in plural. Number 1, we add S. I think those were the only ones. Any more on page 5? Honorable members, we can now move to page 6. What the honorable member for Woolly is said. Wherever you have more than one clauses, the question takes an S. Please note that. Yes, honorable member for Woolly.
Resumption of the assembly. You say, at 20 minutes after 6 o'clock in the evening, the assembly resumed. I thought the assembly resumed. Was it after 6 o'clock or before 6 o'clock?
Resumption. And then the adjournment. Yeah, we closed by 16:30, about around 18:30 or 25. Because remember, we were to do it at 1800 when we said we finish up one clause, only for members to come up with a lot of more observations on it. But technically, you are just being too legal. But 6 o'clock doesn't mean sharp, even a second after it should have been a motion. Because we cannot close at sharp 6. We are only going to close seconds before or seconds after. And it's still after. So that's too technical. Yeah. So, honorable members, as I said on page 6, wherever you have more than one clause, you add S to the questions. Don't forget that. Okay. Any more on page 6? No more. Last page, page 7. Honorable member for Upper Salon.
Yes, thank you, Honorable Speaker. I want to be guided here. Our standing orders on clause 11 stipulates the time we start and the time we close. And it says that we start at 10 o'clock and then we close at 6 p.m. But on this particular day, we completed our transactions at 22 minutes past 6. What is the implication on this? Thank you.
The same implications.
Your attention that we needed, yes. No, normally you move a motion to sit beyond 6 o'clock. Yes, I don't understand maybe.
You can only move a motion 30 minutes before. After 30 minutes, it means we have agreed to 6 o'clock. Yes, it's 6 o'clock. Now, at 6 o'clock, it could be a minute to 6, or 30 seconds to 6, or 1 second to 6. It could be after 6. It may not just be 6 o'clock. The intent of the law is to end at 6. But the intent is not to be not second or some little after or some little before. That's the intent of the law. We cannot do that. Then the people will be standing looking at the clock. As we they tell me, speaker, then I say assembly adjourned. Because even there, it will have adjourned seconds after. So that is too technical. Follow me? And honorable, sometimes, like today, we are asked to start at 10. It's not a problem when we start at 10:30 or 11. And yes, the law, the standing order say 10 o'clock. There was no motion for that, I mean. Standing order is expecting you, every member, to be here so that we start. That's the expectation. So if you are not here, we cannot start. We are flouting the standing order. Who is there?
Yes, in fact, this is clear because we were dealing with some parts. You said, let's finish this part before closing. Somebody wanted to move a motion for us to sit before 6, beyond 6. So you said, are we sitting beyond 6? We said no. And you said, let's finish this and close. So we cannot finish exactly sharp 6 because we were trying to finish that part. So you are right.
It's not possible. Technically, it's not possible. So I think we continue. We are now on page 7. Any comments on page 7? That's the last page. Honorable members, it has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Saturday, 7th December. Guys? Yes, where? Kiang West.
Honorable Speaker, thank you very much. The correction that I was trying to make is on the first one that we have just adopted. It was a mistake that I looked at the recent one. It was on the Friday one that I have just looked at. Yes. So I'm sorry about that. So if I am allowed, I would take the assembly through that. Yes.
Members, it has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Saturday, 7th December 2024 be approved with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, may we proceed?
Bills. Order 72, consideration stage. Continuation of the consideration stage on the Intellectual Property Bill 2023 by the Honorable Attorney General and Minister for Justice.
Honorable members, you will recall that after the second reading, stage, the bill automatically stood referred to the ABC. Thereafter, the ABC scheduled the bill for consideration stage during the previous ordinary session in July. That was precisely on the 9th of July. However, the Assembly could not complete the consideration stage of the Intellectual Property Bill and stopped at clause 24 of the bill during the said sitting, and hence suspended the process to a later date. Therefore, the bill is appointed today for a continuation on the consideration stage in accordance with Order 72 of the Standing Orders. During the consideration stage, members shall have the opportunity to give detailed consideration and scrutiny to every clause and schedule in the bill. This stage also provides the first opportunity for amendments to the bill to be debated and voted on. I will now therefore resolve the Assembly into Committee of the Whole Assembly to give consideration to the bill, that is the Intellectual Property Bill. The Assembly is now resolved into the Committee of the Whole Assembly. Honorable members, the Assembly will now go into the Committee of the Whole Assembly to consider the Intellectual Property Bill 2023 clause by clause. As usual, we will be guided by Order 72 of the Standing Orders during the consideration stage. You do?
That's the report of the committee.
Okay. I'm getting you. We stopped at 24. We are now going to 25. Are we all there? Sorry.
Clause 25, right of priority.
It is proposed that clause 25, right of priority, stand part of the bill. Those, yes, please.
Yes, we will require an explanation because here it is saying, it's a bit technical, but it is saying right of priority. If you are saying it's just 1 day, but what about the hours? I'm making reference to 25.1. 25.1, the application may contain a declaration claiming the priority of one or earlier applications filed for the same invention by the applicant or his or her predecessor in title. So if you look at the second one, he's saying the priority, period of priority shall be for 12 months. So I'm saying if it is less than, for example, if it is 3 months earlier, if I make my application 3 months earlier, and yes, let's say 2 months or 3 months earlier before the other one, should priority not be given to me?
From the first day to 12 months. That's the meaning I attach to it. It's for 12 months. Meaning it cannot exceed 12 months. Or you are giving it another different meaning?
And then the first one, put his application, 3 months earlier than the other one instead of 12 months earlier. Wouldn't priority not be given to that person?
Yeah, let's hear the Honorable Minister.
And two are connected. Let's read two. Yeah. Yes, this is about Honorable Ture. The earlier application referred to here is if you have made an earlier application in another country. Yes. And you are now filing in the Gambia. you can claim priority, you can indicate claim priority in your application in the Gambia by virtue of your earlier application in another jurisdiction. Yes.
Are you fine? It is proposed that clause 25, right of priority, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Yes. They are saying from 9 to... They have no comments. Is that so?
Yeah. From 9 to 45. Yes. Yes.
Let's go.
Clause 26, information concerning corresponding foreign applications for patents.
Honorable members, before I put the question, when he reads it, before I put the question, you can call my attention if you have it. All right? It is proposed that clause 26, information concerning corresponding foreign applications for patents, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 26.
Filing date, examination, grant, and publication.
It is proposed that clause 27, filing date, examination, grant, and publication stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 28, grant of patent, changes in patents.
It is proposed that clause 28, grant of patent, changes in patents, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause.
Exceptions.
It is proposed that clause 29, rights conferred by the patent, limitations and exceptions, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. What's wrong? People cannot say aye or no.
Clause 30, duration, annual fees, and restoration.
It is proposed that clause 30, duration, annual fees, and restoration stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 31, compulsory licensing, order used without authorization of the right holder.
It is proposed that clause 31, compulsory licensing, order used without authorization of the right holder, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Yes, please. Okay. Yes, let's continue.
Clause 32. Clause 32, involuntary license.
This proposal 32, involuntary license stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 33, invalidation, surrender.
It is proposed that clause 33, Honorable Member for Woodley East.
In 33:6. Yes, line 3, where it starts, an interested person may request the court to transfer the granted patent to him or to invalidate the patent. Line 3 of 33:6. The language is not very clear there. A dispute over the right to the patent under this section shall be heard by the court. An interested person may request the court to transfer the granted patent for him or to invalidate the patent. Yes. That's not very clear. To invalidate the patent. Yes. You invalidate my patent.
Yes, Honorable Ture, it is very straightforward. This is where I was thinking maybe whether you're going to say we add him or her, but
patent. I can do that. But for them to invalidate my patent, that's why I have problem.
it's not the person to whom the patent was granted. It's somebody who has interest in a patent granted to somebody else. So he's either asking that he be recognized as either a co-inventor, or maybe the granting was not done properly, so he applied for it to be cancelled. Somehow, it's just somebody interested in the issue. No, not the person to whom it was granted. You cannot apply, hardly, you cannot apply for a patent granted to you to be invalidated by yourself. It's the third party here who is doing the application to say the patent granted to Honorable Ture should either be cancelled or I should be recognized as a co-inventor, so therefore I should be added, or whatever. So these rights is for the third party who has an interest. That's why he started with where there is a dispute, and then he says an interested person. So it's not the patent holder, it's an interested person. Yes, any other person who is interested in the patent. Yeah, we can add him or her, maybe for gender purposes.
By far better. When you say it, it means everything. When you say he or she, it means everything. Not now. Yeah, the old one I said is better. That he, what does it mean? It means he or she. That's the interpretation. Now, this is what I'm saying. I'm not saying it's not changed. I'm not saying that. So where do you put your he or she?
That same place.
Or her. No more or again. Because here it's patent to him or to invalidate the patent. So it's to him or her the patent. Why should the O be removed? No, what I'm saying is, you know, the original text now is to him. The original text. The or is the alternative or to invalidate it. Now you are saying to him or her, that's one, or to invalidate it. The or should still be there. Yeah.
Honorable Speaker, may I apply to reopen clause 32? We just want to make it better. It's clause 32. Okay, all right, okay.
Let me just complete this one. Honorable members, no more on clause 33. No more. Okay? It is proposed that clause 33 stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Honorable, you said what?
We wish to apply to reopen clause 32. We think we could make the drafting much more clearer. Yes, that's what.
Honorable Chair, I move that we rescind our decision on clause 32.
Honorable members, any seconder? Yes.
Thank you. Honorable Chair, I second that motion.
That we rescind our decision on clause 32, involuntary license. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So our earlier decision has been rescinded. Honorable Minister.
Thank you very much, Honorable Speaker. If you look at the heading on voluntary lancing, here the objective is you might have a license holder who is refusing any third party to use his license. For example, in medicine, you invented a medicine, but some other people are interested in being authorized to manufacture, let's say, generic copy of those medicine, but the holder continues to refuse. We're giving authority here to the Registrar General with the approval of the Minister to be able to, even against the will of the license holder, to authorize certain third parties in exceptional situations to use the invention. So, what the language we wanted to clear, right now we would want to be clear. It says the Registrar General in consultation with the Minister may authorize the use of invention by a third party. So we just want to improve on the lancing to say the Registrar General in consultation with the Minister may issue an involuntary lancing to authorize the use of invention by a third party, so that it's much more clear. So I can repeat what I said now. And I'll show you where the corrections are.
Continue.
The Registrar General, in consultation with the Minister, may, so there we are inserting something now, after may, issue an involuntary license. Instead of authorize, we are now saying issue an involuntary license to authorize the use of an invention by a third party. So all that we inserted it, issue an involuntary license to. Yes, but you recorded what I just given. It continues. The text of the sentence continues.
Yeah. He said the Registrar General, in consultation with the Minister, may issue an involuntary license to authorize the use of an invention by a third party. Okay.
Hello? Yes, I'm trying to, let me preempt you. The payments will still go to the patent holder. He will continue to benefit. But for the public good, for public interest, we sometimes can override his refusal for the benefit of the public. That's all we are looking at here, public interest. Yeah.
Wouldn't you not seek for the, wouldn't you not consult the patent holder before you do this?
No.
It's a situation where you invented something. Of course, by virtue of invention and you register it, you become the patent holder of that invention. And it's your right to limit the usage of it. But if this happens to be something for which the public interest is needed, for example, if it is medicine and is critical for the public health of the country or for society, and you still refuse him because you are the license holder, public interest can override your license rights. So we can now use the authority now to allow other people to produce that thing against your will. The benefit will come to you, but the greater good is what we are looking at here. Yeah.
Honorable Busumbala.
The ministry is involved in the grants of the patent to this inventor. So using the same system, to override his refusal may not look good. So I believe the court should come to a play here.
This thing, and you feel you are not satisfied, you resort to the court to rescind the minister's deal because they are the administrators. Yeah, I'm saying something, Honorable.
Yes. Thank you, Honorable Speaker. Honorable Minister, Honorable Chair, for me, I want clarification. What if the refusal of the patent holder is based on lines of competition? For example, a particular manufacturer wants him to give him the patent, but currently he's giving it to others who are producing and they are within the same market and the supply is sufficient. Would you still override?
Honorable Speaker gave the answer. This decision is a regulatory decision. If the patent holder is not satisfied with the registrar's decision, the court will separate them. The matter can go to court and they will be separated by the court. The court will decide whether the registrar acted properly in public interest or not.
For clarity, for us to add in the public interest at the end. Because that's what I think will solve the problem. Yes? Yes, Honorable. Nominated member.
Okay, Honorable Minister, we just want to be sure that we know the courts are the last resort, but we just want to be sure that, the decision of the Registrar General and that of the Minister are guided.
we shouldn't rely on the courts as the last resort. So is this decision taking into consideration competitiveness and whatnot? Because that's important. I might refuse to grant permission to the competitor of my customer. Now, the public interest would be where we have insufficient supply. But in this case, the individual I've given the patent to is operating in the market and the supply is sufficient. Would the registrar still override it?
When we're talking about patent here, you have a license to a unique product that nobody else has. So I don't see competition here. So this is a unique product that which you have the right that nobody can reproduce without your permission. So it's the issue of, if you don't give permission to anybody, nobody will produce it. All those you allowed to produce it, the royalties or whatever is coming to you. So we are just asking you, can you allow us to produce it probably cheaper and more, and in larger quantity for benefit of the public? If you say no, because of the public interest, we will override you, but purely only for public interest, not for market or for any reason. And that's the only time this thing is invoked. And usually the courts are always there to separate the Registrar General from the, because even the actual application to register itself, Registrar General could have refused you the right to register. And you will always have to go to court to challenge the Registrar General's decision.
Yeah, Honorable, you are proposing that we add at the end of the party in the public interest. Is it going to be, is that okay, in the public interest? Yeah, okay, all right. All right, honorable members, for that amendment, yes?
So, yes? Okay, I'm saying yes as if I'm the speaker.
Honorable Speaker, public interest here needs to be defined. No, we need to know. Because exactly what I was asking is where the Honorable Minister landed. The patent holder have a unique product. And my question was based on the fact that the companies who have issued the rights to produce this product are locally present in the market. And there is no insufficient demand. So now, what public interest are we protecting that will warrant the override of his powers not to allow other companies to use it? So I believe that safeguard of public interest is not sufficient there. We need to know.
It is evident that there is public interest. For that to be determined cannot be in the law. That is going to be determined at the court. If you feel that the minister, just like my compound, it can be taken from me for public interest, my compound. Now, that public interest may be anything, a school, whatever or whatever. If I feel offended, I go to court to say no, challenge that decision. But you will not find there public interest means school building or this thing. No. Yes, Honorable Minister, you want to say something?
So we now said the Registrar General, in consultation with the Minister, may issue an involuntary license to authorize the use of an invention by a third party in the interest of the public. In the interest of the public. Yeah? Now, for you, Honorable, take a situation like the crisis we just emerged from, the COVID crisis. It came out, there was no cure. Assuming the first person that produced a medicine to a cure to COVID-19, and he registered it, he becomes the inventor of that medicine and has patent right over it. he probably is only granting permission to the bigger pharmaceutical companies for money purpose. But meantime, people are dying. It's a pandemic. Now, we have to allow him to enjoy his lancing while people are dying. In some situations, for the public interest, we tell him, look, whether you grant us right to produce this or not, we will allow people to produce it. It might be your invention, but for the urgency and because of the public interest at stake here, I mean, your commercial interest of owning the patent alone, I think if we protect that alone and forget the public interest, what do we do? You see the point? Yeah. Can challenge, yes.
Yeah, thank you very much, Honorable Chair. Nyanija, yes. Yeah, just for convenience. You know, initially I wanted to ask the issue that the minister is explaining, but by his explanation I was convinced. But Honorable Minister, is there not any likelihood that this particular issue can be used against somebody?
Any kind of discretion that is vested in a human being by law is subject to abuse. We have to be clear about that. Any power that you vest in a human being, by our nature, is subject to abuse. But that's why the controls are there, like Honorable Speaker said. If you think that decision was exercised wrongly, you challenge it. But as a general rule, I don't see any kind of power that you can entrust a human being that is not prone to be abused. So I cannot guarantee you that the register may not, one register or another register may not somehow abuse this. But once it is abused, that's why we have the accountabilities and the checks and balance systems. When you believe somebody exercised a power vested him by law or by any kind of authority, you think it is exercised wrongly, you challenge it. But fear of being abused also cannot make us shy away from entrusting discretions in authorities. Because if they don't have discretions, the day that we would need them to exercise that discretion in the interest of the public, the power would not be there because we are not giving it to them. But the abuse is going to be in the minority. It's not going to be the day-to-day thing.
Even if you abuse it, your authority can be challenged and it can be rescinded or thrown out. Yes, somebody was saying something. Yes, nominated member Keva.
Yes. Honorable Speaker, to start with, I'm convinced by the minister, but now we need to look at the controls. The only thing you have there is to say that the minister or the Registrar General can do this in the interest of the public. Now, when they go to the court, as a parliament, in legislating this law, we haven't put any safeguards, which the court can look at and know our intent as to what the minister or the Registrar General can rely on. So what is the court going to use to evaluate whether that decision was done in accordance with the law or not? There are no safeguards.
There is an overriding provision, whether stated here or not. I'll check in the rest of the legislation. But Registrar General is a creature of law. That office is a creature of law. Every lawyer knows that as a general rule, and any decision he made is challengeable. Because you will realize that there are all over this legislation, various powers are given to Registrar General. But you realize ultimately whatever decision he makes is subject to be challenged. He is not immune from being challenged. In fact, every day he is being challenged in the courts currently. The patent owners, the traders in this industry knows that. They know that Registrar General's decision is not necessarily final. They are always challenging it in court.
Or somebody, or there are crisis in the interpretation of a constitutional provision. It goes to the Supreme Court and they make their interpretation. They make their interpretation, whether for me is right or wrong, that's what holds. So there must be that form of authority there. Now for this particular one, it's just like people in positions of trust, until otherwise, you take them to be serving in the best interest of the people. That when you go to face them, they will look at the best interest of the Gambia.
Honorable member, if you go to clause, we are a bit away from there, but if you go to 87, appeals, clause 87, 1, a person aggrieved with any decision made by the Registrar General in respect of international registration's designation, the Gambia may appeal therefrom to the tribunal. There is a tribunal for this. Any decision of the Registrar General that you are aggrieved with, you can challenge it. Yeah.
Honorable member for Wood List.
Where you have the 8 on the same clause, 8. It says a patent may be surrendered by its holder. You know, in 7 it is saying the court shall be notified to the Registrar General, who shall instruct the register to record it and publish a reference thereto. So if that is done, now you come and say the patent may be surrendered. Why is it may? Why don't we put shall there? After the court has decided.
Read the whole 8. 8. Read the whole thing.
Patent may be surrendered by its holder. The surrender may be limited to one or more claims. So I'm saying after the court has already made a ruling and it is notified, why is it a may? Why should the person be given an option to keep it or to surrender it?
It's giving you the right to surrender your patent. That is different from the court order. The court order cannot be may. A court order is binding until appeal against. Yeah, 7 is by itself. And the other one is another information. That's what my belief is. You may be right, but let's get to them. Honorable Minister, you follow his question?
Yes, this is a situation where a patent holder's right over the invention is challenged. The court may invalidate if the matter goes to its logical conclusion in the court. But just by virtue of the fact that it is challenged, the holder may surrender it. That's why you say may. You may surrender it instead of waiting for the verdict. Especially if you are not too sure of your position, you can say, you know what, there is no point for all of this, I'm giving it up. So that's what we mean here. You may surrender.
In 7, we want to hold the Register General, that's the one we want to hold. But you're saying the Register General who shall instruct the register. So it's now the responsibility is coming from the Register General, is going to the register. You see it in 7. A final decision of the court shall be notified to the Register General who shall instruct the registrar to record it and publish. The one that is responsible is the Register General.
Registrar General is the head of that place. That's why the court order is addressed to him. But under the Registrar General, you have registrars of different things. A registrar of patent, a registrar of this, registrar of this. So the Registrar General is the overhead. So when he receives the court order, he directs the person in charge of the registry, that particular registry, to action it. Registrar General. Registrar General is the overall. Yes. That's why the court order is addressed to him. But then he will instruct the registrar in charge of that particular aspect to implement. Yes.
Like anything comes to Parliament, goes to the clerk. West.
Honorable Chair, 3, subsection 3, which reads the Register General or the court shall invalidate the patent if any section of the Act is not complied with. If any section of this Act is not complied with. But if any section of the Act is what we have here. Can we have it as if any section of this act is not complied with.
Member for Kiang West. You are gradually becoming a legal draftsman. You honorable members, number 3. The second line of 3, any action of the act. It should be any action of this act. Sorry, any section, sorry. Of this act. Thank you very much. Any more on this instead of the? We are now putting the question on we are proposing an amendment to 32, if you remember. That was what brought about all this. Now, I now put the question. It is proposed that clause 32, involuntary license, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. And then 32, I think that 33, we have done it. We have done that. Then it means we are going to rescind our decision there. On clause 33, invalidation, surrender. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So it is rescinded. I now put the question. It is proposed that clause 33, invalidation, surrender, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 34, international applications under the Patent Cooperation Treaty.
Yes, Honorable Minister.
So, Honorable Speaker, with your permission, we apply to defer clause 34 because it is making reference to the copyright, the Patent Cooperation Treaty. We want to go and bring them and fully domesticate them instead of referencing them. So we give the drafting time a little bit of time. They will have to bring it down and fully incorporate it here instead of, because it says the specific meanings of, the following words have the same meaning as in the Patent Cooperation Treaty. We say no. We will go to the treaty, bring those meanings and incorporate them here so that we fully domesticate. So they will need time to do that. So I would apply that we skip clause 34 while they develop that. Hopefully we can come back and adopt it when it is done. Hopefully, depending on our speed, we will be working on that. Hopefully by the time we finish, because these treaties are available online, so they can quickly reference them. By the time we come back from lunch break, yes. Clause 34, we apply that it be deferred.
Members, clauses 34 and 35 are deferred until later. Yes?
We know why clause 34 is deferred. Can we be specific on why we are deferring clause 35 as well? No. Let the minister come. We know why 34, because the definitions have to come for those terminologies. So why are we deferring 35? So that we would know when it is complete. Yes, in that case, that's fine. No, the main reason I asked Honorable Speaker is, in the case of clause 34, they indicated that they will bring the patent cooperation treaty and domesticate it. And the definition of the terminologies there will be the ones used. So we want to be sure as well what they intend to do in clause 35, so that when they come, we can be on the same wavelength.
What I'm saying is, they may not even be specific to know, but they think how it is should be changed. So, but when they finally bring it to you, you look at it against what you have, you can still say yes or no.
Let's go to the next.
Clause 36, receiving office.
It is proposed that clause 36, receiving office, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
37, filing of international applications with the office.
It is proposed that clause 37, filing of international applications with the office, stand part of the bill. Those in favor, please say no. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 30.
Clause 38, the office as designated office.
It is proposed that clause 38, the office as designated office, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 39, the office as elected office.
The clause 39, nominated member, Keba.
Clause 39 is equally making referral to the Patent Cooperation Treaty. So do we defer that one as well?
Can you read the patent 39, Keba?
Clause 39, the office as an elected office. The office shall act as an elected office in respect of an international application in which the Gambia is designated if the applicant files a demand for the purpose of international preliminary examination under the Patent Cooperation Treaty. So I'm saying this clause also is making referral to the Patent Cooperation Treaty. So do we treat it as we treated 34 and 35?
What's the essence of legislation?
You know, our problem, Honorable Minister, have you heard Honorable Minister? Have you heard him? The question? He is saying similarly, 39 is talking about the Patent Cooperation Treaty. And you know, international treaties are, if they are not domesticated, they cannot override our laws. Making references to international treaties without domesticating them becomes a problem. Because by our own laws, it doesn't mean when you sign an international treaty, it is domesticated. Other countries, yes, but not for the Gambia. you legal people address our issues? Because for us, we believe that international treaties are not binding in the Gambia or supersede our laws unless they are domesticated. No, it's the technicians talking to themselves first. You know, our worry is, for instance, we know our international treaties or conventions that we sign, unless they are domesticated, for instance, our laws supersede it. If it is specific in the law here, it's more relevant than the treaty or whatever we have signed. So the concern raised on 34 is what motivated the honorable nominated member to say, what about 39? Shouldn't it be the same? And somebody was also saying, I don't know whether it was 36 or I don't know what. Yeah, but we have done that. 39. Can we do it this way first, honorable members? Because of the earlier concerns raised on 34, and it goes to 35, and 36 also is our concern. Why don't we put all that also aside? Let them look at all of them and come back with one solution. Yes. Yes. 39. Yeah, when we read that. Yes. All right. 34, 35, and 39 so far are deferred. Okay, we continue.
Clause 40, processing international applications.
It is proposed that clause 40, processing international applications, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 41, entering national fees.
It is proposed. Member Keba, microphone.
Can read clause 41 for you. With your permission, Honorable Chair. It says, the applicant shall, in respect of an international application, designating the Gambia and before the expiration of the 30 months time limit applicable under the Patent Cooperation Treaty, or of such later time limit as may be specified in the regulation to this Act, pay the national fee to the office and file with the office a translation of the international application into English by the international application, if the international application was not filed in, and has not been published under the Patent Cooperation Treaty as translation into English. So do we defer that one as well?
Talking about if the application, if the international application was not filed and has not been published under the Patent Cooperation Treaty as a translation into English. Those are conditions for those things to be translated and accepted. Yes.
That's what is there.
Nominated member, are you fine? Huh? All right. I put the question. It is proposed that clause 41, entering national phase, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 42, failure to enter national phase.
List
does not comply with the requirements of section 42. So I believe it should be 41 or another section, but not the same section. You've seen it.
AG, you have seen it? Yeah, 42 is in, we are on 42, you are making compliance to section 42. I think it may be another section that you want to mention. Which other one should it be? So it should be 41 instead of 42. Huh? So, honorable members, clause 42, last word on the first line, section 41 is instead of 42.
Act within the time limit referred to in that section. It should be section, not subsection. 41 doesn't have a subsection.
Last word in the second sentence. Instead of subsection, it should be section. Yes, please. Yes. Mbala.
And if you look at 41, it makes specific reference to the Patent Protection Treaty. Oh, but this is the main treaty it is referring us to. And this treaty is not been domesticated. So are we going to, it is going to be binding?
Remember, is that this is talking about
the publication made under that treaty.
Yes. Yes. If the international application was not filed in and has not been published under the patent, these are criteria set for you to have that interpretation accepted. Where are we? It is proposed that clause 42, failure to enter national phase, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 43, reinstatement of rights after failure to enter national phase.
Yes, honorable member.
We have the same issue there. It's referring us to 43 when we are dealing with 43. So it must be.
Have you seen it, honorable? The reference is still to itself. It's making reference to itself. Yeah. It will be, so we put 42.
42, 42. Okay.
Honorable members, check clause 43. The second sentence, you have section 43, it should be section 42. On the fifth sentence, second to last word, section 43 should be section 42. Have you seen it? Okay. No more. It is proposed that clause 43, reinstatement of rights after failure to enter national phase, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 44, restoration of right of priority.
It is proposed that clause 44, restoration of right of priority, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 45, processing international applications in accordance with the Patent Cooperation Treaty.
Do I put the question? The yardstick you are using has changed. If we are using the same yardstick. "45. Read it through. Honorable Member for Woolly, help us read through.
The office shall process international applications
We defer clause 45.
Clause 46, utility models, applicability of provisions relating to patents.
It is proposed that clause 46, utility models, that is applicability of provisions relating to patents, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 47, special provisions relating to utility model certificates.
It is proposed that clause 47, special provisions relating to utility model certificates, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 48, conversions.
Kia?
Clause 48, number 1. At any time before the grant or refusal of a patent, an applicant for a patent may, upon payment of the prescribed fees, instead of convent, it should be convert. 48, 1. Prescribed fees. You have convent there, instead of it should be convert, not convent.
ERT, yeah? Honorable Minister. Is that all, Honorable Chair? Yes.
Yes, it says an application may not be converted under subsection A of this section more than once. I've not seen any subsection A. Subsection 1? Subsection 1? Yes.
Subsection 1. Thank you, Honorable Member for Woodley. Yes, please.
You know, it's saying at any time before the grant or refusal of a patent, an applicant for a patent may, upon payment of the prescribed fee, he said, convert. This prescribed fee, is it talking about the patent or the utility model certificate? The fee to be.
The utility model.
Oh, yes. Anything? Before I put the question.
We could even clarify to say on clause 3, we can say an application under subsection 1. You know, to make it clear, clause sub 3. An application under subsection 1 may be converted more than once. May not be converted more than once. An application we can insert under subsection 1 to be clearer.
Amendment to clause 3. The first amendment is not, we are not taking that one yet. It should be an application under subsection 1. One may not be converted more than once. May not be converted more than once, am I right? For more than once. May not be converted more than once or for more than once. You said we put 4. So it will read this way, honorable members. An application under subsection 1 may not be converted for more than once. That is it, honorable minister?
I thought we were fine without 4.
More than once. May not be converted more than once.
More than once. Remove the 4.
An application under subsection 1 may not be converted more than once. So I now put the question for the whole clause. It is proposed that clause 48, conversions, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. It looks like my brothers from the center of the Gambia. I don't know what's happening, whether no good breakfast or what. No, the center of the Gambia is LRR.
Clause 49, subject matter of protection.
It is proposed that clause 49, subject matter of protection, stand part of the bill. Those, yes, you want to say something?
Thank you, Honorable Chair. I just need some clarification from the Minister. When you talk about registration under this section shall not be granted to a design, the feature of which are dictated solely by technical and functional consideration. Is it that they're talking about, let's say, if you have an architecture kind of who invented a design kind of that is technical, cannot be registered, or what? What is the section talking about exactly? Because I didn't understand. It's talking about technical and functional consideration.
Honorable Minister, he said registration under this section. Because this section there is no talk about registration. I don't know whether you see me. 49 is subject matter of protection. And he's saying registration under this section.
Okay, Honorable Speaker. Yes, the clause essentially is saying that a design cannot be registered for protection if its features are solely determined by their technical functions rather than their aesthetic reasons. Because a design generally refers to visual appearance, form, or aesthetic features of a product, which can include lines, colors, shapes, texture, or other things. So when it is purely a technical thing, usually that is not registered and protected. So it's not the functional features that usually are protected. Is the ornamental or aesthetic features of a design that are protected. So when it is very technical to functional, joining things to achieve a particular function, those are things that the laws don't protect.
So it is, yes. So let me just in terms of implementation, under this bill, who determine what is technical in it? Who determine that? Is it the Registrar General? The determination of what is technical in the design. Whose responsibility to determine that? What is technical in the design exactly, so that.
So when submission is made for registration, the Registrar General's office is made of trained staff, so who can make their assessments. Currently, is full of master's degree holders in intellectual property law, so they know these things. When applications come, they do assess. By look of it, they know whether this meets requirement or not. But like we always repeatedly say, if you want to register something and you think you are unnecessarily denied the registration, the court can always resolve.
Yeah, my question is, how about if this technical and functional consideration are part and parcel of working to make that particular design workable? How about if the component is part and parcel of it? You are going to deny it based on technical and functional considerations. How about if they are part and parcel of that particular product?
Now, if you look at this legislation, it's covering a broad range of various aspects of IP law. If it is a part that you think you invent, then you go for patent, not design. You can register it as the inventor of a particular part. But the combination of parts to achieve a particular functionality, if we allow that to be registered, then we will limit, we will not be able to encourage people to produce. But if you are responsible, you're claiming ownership of different parts that make up that thing, then you register the parts that you think originally you are the one that invented them, and then you have a patent right over those parts, but not the joining of those parts to achieve a function. Then that will become a problem. All right.
It is proposed that clause 49, subject matter of protection, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 50, registrable industrial designs.
It is proposed that clause 50, registrable industrial designs, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 51, right to registration of industrial design and naming of designer.
It is proposed that clause 51, right to registration of industrial design, naming of designer, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 52, application and right of priority.
Yes, Honorable Member for Wole East.
Chair, 52(9). The last line. Or let me just read. If the Registrar General finds that the conditions for the right of priority or the requirements for claiming priority have not been fulfilled, the declaration claiming priority shall be considered not to have been made. So I was thinking that why don't we say it is either declared null and void or is cancelled? But then you come and say the declaration is made when it is already made. I don't know why they put it that way. Why don't you just cancel the declaration, or it is made null and void, rather than saying the declaration is seen to be not made?
Already been registered. It's only the filing that's done for you to be registered. Now, those filings and without those conditions, it means just like you have not done anything. So I think that's what he's trying to say. The conditions are not met.
Which means you have already applied, but then your conditions, you have not met the conditions. So why should they say now, because you have not met the conditions, so you have not in actual fact made any application? They either cancel your application or they nullify it, or is considered null and void if you don't meet the conditions, but they cannot say you have not made an application.
Of that, they are considering that you have not made an application. Because making an application that has not made these things, for them, it means that. But you want it to be changed to either that application is invalid or is nullified or whatever. That's what you want.
No, it's a bit technical here. With these filings, this issue of priority, in fact, is very critical for those who file for these rights. So you make a declaration in your application that you have priority, either probably because you have applied it somewhere in Liberia before you have a number for it. But if the register discovered later that you have not fulfilled the conditions, the proper language is you will be considered not to have even made it properly. With these filings, unless the register accepts your filing and allocate you a filing number, even if you submit all the documents, you are still deemed not to have filed yet. It's when your registration is accepted after filing, and before register accepts it, it looks at all the preconditions. So it's very critical we maintain this technical language. It will be deemed not to have been made at all. So that otherwise you can go to court and claim that you have made it. And usually priority is allocated based on making it. But we are making it clear, even if you declare it in your application that you have priority, if the register discovers that all the condition precedents have not been fulfilled, the legal effect of that is as you have not even made a priority declaration.
Nominated Keba.
Honorable nominated member Keba.
Thank you, Honorable Speaker. Honorable Speaker, before making any observations, I just want clarity on 52.7. If they can explain to us, 7 years. Huh? Honorable Minister.
There are questions on this 52.7. Yeah, 7, sub 7. Yeah, the effect of, you can read it.
The effect of claiming priority shall be as provided in Article 4B. Do we have 4B of the Paris Convention? Okay. In particular, an application filed within the priority period shall not be refused or invalidated by reason of any. Now, we can. The team will continue to look at these things. What I'm not too sure whether we will even come up with a different position. With intellectual property, it is global. And it's very international in the way these applications happen, because it's a system where one application in a country gives you a global right, or sometimes it gives you a regional right. So I don't see how we can have an intellectual property legislation without making reference to those global instruments. And if we say every time we reference those instruments, we have to domesticate all of them back home, it will be a challenge. But we will look at it. Since it is raised, we will look at it again closer. But that is why you have the World Intellectual Property Organization, WIPO, and you have the Africa Regional Intellectual Property Organization, SARIPO. This is very international in nature, and their transactions. So you can register in one country, but by virtue of these treaties, you enjoy the right to all countries that are a member of that organization. So, and it's automatic. And the only thing that makes those things automatic are the treaties. So if you are writing a domestic legislation, you must reference to those treaties. This is a unique industry, it's a unique kind of thing. So yes, we are aware that we are a dualist country. When we reference treaties, they don't automatically apply in our domestic laws. But we reference them because whether we recognize them or not, they are applying by virtue of our membership of those organizations. And we are receiving revenues because when they register in a given country and register an IP product that they want to enjoy the right in the Gambia, part of that registration fee, even though it is done in that country, we get our share of it. And these are all by operation of treaty. But like I said, we will look at it, and then the experts will look at it with the drafters. This is going to be a debate between the experts and the drafters, and we will look at it holistically and come back to you. But I'm not too sure whether we may even return a different conclusion, but we will look at it.
Clarity, and then we may accept it. Yes. So we are putting clause 52 also deferred, but this one is 52.7. But because of that, we are deferring the whole 52.
Yeah, clause 53, filing date, examination, registration, and publication.
It is proposed that clause 53, filing date, examination, registration, and publication stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 54, rights conferred by registration.
Yes.
Issue at clause 54. The registration of an industrial design shall confer on each holder the right to prevent others from exploiting the registered industrial design in the Gambia. This right shall extend to designs that so closely resemble to the registered industrial design that they produce the same overall impression. Attorney General, here it seems to me we are restricting others to be innovative in a very similar area. Let's look at the properties. Even something very closely resemble does not mean that they are similar. So it's like we are trying to restrict innovation. If you have a particular design, we are trying to restrict innovation around that design. Let's look at it properly, please.
Or also prevent stealing from people's designs. Because you can also, you have no idea, you just took it and then you just add 1, 2, 3 just to make it a little bit different. Yeah, you had his fears.
I heard the honorable member, but that is the very purpose, what is the law, that's the very reason the law is protecting, because it's protecting copying. If it is so similar that it can cause confusion in the eyes of the general public, then it's too close. And that is the right that is being protected. Because otherwise you will start something and somebody will pick it and take everything that you have and just adjust a little bit. And then he claims ownership of it. So that very similarity itself is what is being protected. Because it shouldn't cause confusion. If somebody invented something, an industrial design, you have to design something completely different. Otherwise, you will take his design and just tweak one or two things and say, but they are just similar, but they are not the same.
Honorable Member for Upper Salu.
Yes, I also wanted to confirm from the Minister, how does this one in particular affect generative AI, artificial intelligence? Because normally they use various data sets that picks up several designs are put together to create something. So meaning they may pick certain things from already designs that are already maybe copyrighted and put together using various machine language and stuff. So how does this one in particular protect that? Because AI generative one, it's like machine language. It picks from different aspects. And those are already protected. But then you pick from all and then you generate it. How does this fare well with the artificial intelligence that we actually have nowadays?
The laws around AI issues are developing. But one thing is clear, the creativity here that is being protected is the contribution of the human mind, not the machine. So I don't know whether you're saying if the human industrial designs are protected, people who use the machine to copy, they will not enjoy the protection. It's the original designs by human beings that are already protected. So if the machines are used to plagiarize that, the creation of the machine will not enjoy protection over the human mind creation. I don't know whether I got your question clearly. Because, all right, let me hear you again.
What I'm saying is, when you currently there's an issue of intellectual property and artificial intelligence, because artificial intelligence uses data sets to create something. So these data sets actually come from a creation of somewhere, and they put together, and they train the machine to be able to be more intelligent than the human mind, so that they can create something. So as a result, in the creation, something actually they get sources from various areas to create something. But that's something, if you look at the underlying principle are data sets, but it's not in full. They just pick here and then allow it to create something, not the human mind, but the machines are actually going to create that. So how does the protection, I know it's a big issue right now. So how does this intend to protect those data sets that may be derived from multiple sources in the creation of something which is quite different from what you have protected?
That's what I'm saying. Currently, those products are not enjoying the protection of law at the moment. They are not. It's not allowed, because unless you can prove the percentage of human mind contribution to that creation, if it's purely a machine design, I don't think they're enjoying intellectual property law protection.
Yes, the European Union actually, and the Parliament actually came out with, I think, the first act that's actually going to do the protection. You're going to see that even if you generate that outside the EU, it must comply with those acts of Parliament that was created by the European Parliament. So, I don't know.
The last to catch up. So,
you are fine now. I now put the question. It is proposed that Clause 54, rights conferred by registration, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 55, duration of registration and extension.
It is proposed that yes, sorry.
We need some clarification from the minister as to the registration for a period of 10 years. Is that international standard, or is it just what the bill intends to do? Is it international standard?
It is proposed that clause 55, duration of registration extension, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 56, invalidation.
Honorable member for Wole East.
We say a interested person. We just say uninterested. An interested person may request.
Yes, and two.
It's more of English than the other one. You don't say interested. Grammatically. No, in grammar, you don't use a for these words that start with vowels. Yes, necessarily, unless they have given you the exceptions. So, honorable members, the proposed amendment is on 56(1). A interested person should read an interested person. I now put the question. It is, yes? Honorable nominated.
Speaker, 56(2). Just an earlier correction that was made. If you look at our rate, the registration shall be invalidated if it is established that the object of registration is not an industrial design in accordance with the provisions of the Act. It should be this Act, in accordance with the provisions of this Act.
Second to last word on third line, this should be this Act. Thank you, Honorable nominated member Keba. It is proposed that clause 56, invalidation, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 57, exclusive right to a mark.
That clause 57, exclusive right to a mark, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
58, non-registrable trademark.
It is proposed that clause 58, non-registrable trademarks, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 59, application for registration of a mark.
It is proposed that clause 59, application for registration of a mark, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 60, examination, opposition, and registration of a mark.
It is, yes. Honorable nominated member Keba.
Just a general observation. In the bill, referral is always made to this Act. So why don't we change it to this bill and wherever it occurs? It is not yet an act. No, yes, I know they're assuming our future decision, but we need to do the right thing. Currently, it is a bill. Yes. No, but currently it is a bill. It is not yet passed. No, allow me. Honorable Speaker.
All right, Honorable, you were saying, two of you were talking. You are saying, I think the Honorable member is saying, instead of this act, it should be this bill. And then this other Honorable member for Upper Salum said what? At the time, there will be no more amendments. So if you leave the bill there, it will be bill until it is enacted and you want to come and amend it. That's why you make it an act so that when it is passed and then assented to, the act is still correct. The bill will no longer be correct. You are dealing with?
Issue at 65. Okay, let's.
Page 8, where you have a bill entitled Yes, on top. You see, a bill and an act. It's not, they did not say a bill entitled to, a bill to consolidate. They say an act to consolidate. So, pardon? Okay. 60. Somebody is Honorable Woolley East.
65. Second line, the Registrar General shall send a copy to the applicant and within 1 month after the receipt of the notice or such further time, not exceeding 3 months in all. Okay. Well, it's increased to 3 months.
This propose the clause 60. Yes, who? Honorable nominated member.
Honorable Speaker, I would refer you to 60 subsection 12 and 13. Yes. Where reference is being made to WIPO, where Gambia is has been designated by virtue of the Madrid Protocol for the international registration of marks. That is for 12 and 13. Reference is being made to ARIPO, in respect of which the Gambia has been designated by virtue of the Banjul Protocol on marks. So my question would be, if we legislate this and it becomes law, and we haven't domesticated these international treaties, does it become binding? What will be the ramification of our actions? Yes. Yes, Honorable Speaker.
Is to come back. East?
65 again. Because he's saying within 1 month after the receipt of the notice or such further time, not exceeding 3 months in all, as the Register General may allow. Now it's at the discretion of the Register General to make it 3 months, but the requirement actually, the period is 1 month. So I'm questioning whether we should really leave it to the caprice of the Register General. Why don't we just say for 3 months rather than to leave that at the discretion of the Register General?
Just like we are asked to make laws for the Gambian people. So now, the Register General, if you are not satisfied or if it is something else, because he's giving you, there may be reasons that 1 month may not be sufficient. And therefore, he may extend it for you to 3 months. What is bad about that?
It's going on and off by itself. It's now the discretion of the register to increase it to 3 months. But the period is 1 month. So I'm saying, why don't we give the applicant the opportunity for 3 months, rather than saying it's 1 month, but left to the registrar, it can be 3 months. That's my issue there.
Of things. You give something like you say on conviction. You may this up to or this thing. You can be cautioned by some magistrates when if it is another magistrate, he will convict you and sentence you to 1 month. These are discretionary powers given based on trust. Yes, if we don't want to see that, it will give us some problems in a lot of other issues. The authority concerned, it can be anybody, is taken to be credible until proven otherwise. We say it's 3 months. Fine. 3 months is good. But sometimes you may see something may come up that may warrant that not within the 3 months, for whatever reason is justified, and therefore another month can be added. Somebody should be there to be able to do that. If you bring tangible reasons, just like when we have problems, we go to the court, we find somebody sitting. How good is it that we say that person is fair enough by his judgment? How many judgments have we said this one is saying is not correct, the other one is saying is not correct? These are things of part of life. But he's the one sitting over there. For we have to give discretional powers to people sometimes unless if they are violated, we challenge them. We can challenge them in court. Yes, Honorable. Let me put his question because I was just expressing an opinion. I think. Let me ask the Honorable Minister to explain. He's here. Honorable. He is on section 65. Huh? 5. Well, yes. He's saying the time given is 1 month, but discretionary power is given to the to extend it to 3 months where necessary. That's why he said, why don't we just make it 3 months and then give discretionary power to the AG could be abused or something could happen. Why don't we just make it?
So Honorable List, this is normal. 1 month is what is given. If everything is equal, they resolve it as quickly as possible. If a party needs extension, that is when then the 3 months extension is given. This is pretty much close to the rules of the High Court. High Court civil cases, when you sued under a writ, anyway, you have served, you have within 1 month to file your defense. If you know within the 1 month you cannot meet it, you cannot be able to file your defense, either all your evidence are not yet in place or whatever reasons, you apply to the court. The court can extend, some say extend the time or give you more time to file your defense. But the court cannot give you more than 3 months total. So pretty much it's the same thing here. 1 month is your first option. If it cannot be made within 1 month, the registrar has a discretion to extend. But the totality of extension cannot exceed 3 months. It doesn't have to give you even 3 months. If you needed only 2 weeks extension, he will grant you 2 weeks extension. Yeah. But the maximum is 3 months. Now, it's a discretional thing. You have to justify the request for it, even in the court. It's not that because the court can give you extra 3 months, or that means you can just come and give me 3 months. You have to exhibit evidence that has to accompany your application, because your original timeline is 1 month. So if you say you need more than 1 month, you have to put reason before the person that is making the decision. It's not exercised arbitrarily. Yeah.
Even in Parliament, Chairman Petition Committee, you have some discretionary powers as chairman. Unlike other members who are with you, and you exercise them. How good is it that we believe that you will not be like Fabakari, as bad as I am?
Last person.
We have to be doing this. The way you trust others as you trust yourself until you see them do otherwise.
Until the contrary.
Yes. Yes, Honorable Nominated Member Keba.
No, Honorable Chair, as a member of the Petitions Committee, I just want to tell you, he came to this August Assembly. We were given 90 days, but he filed for extension, and you granted him. We were allowed to present after 6 months. So it's just like in the High Court. He is exercising his powers.
It is proposed that, Honorable Nominated Member, thank you very much. It is proposed that Clause 60, examination, opposition, and registration of a mark, stand part of the bill. No amendment.
No, that one you said we are suspending.
Yes, we said, yes, you raised some things on it. Honorable Minister, in your absence, whilst we were waiting, on clause 60, subclauses 12 and 13, Honorable Nominated Member raised some concerns, just like the previous ones. Yes. The WIPO and the ARIPO and all these things.
WIPO is World Intellectual Property Organization. ARIPO is Africa Regional Intellectual Property Organization. They are not treaties per se, they are organizations of which we are members.
Yes, Honorable Speaker.
The difference, you are now informing us that this is not a treaty, but an organization.
It's just like mentioning EU or mentioning ECOWAS in the legislation, which we are members.
Honorable Nominated Member, your opinion? Are you satisfied?
Clarity, Honorable Speaker. Honorable Speaker, if you read the provision, yes, 12, it is saying, a mark registered by WIPO in respect of which the Gambia has been designated by virtue of the Madrid Protocol for international registration of marks shall have the same effect in the Gambia as one registered under this act, except where the Registrar General communicates to WIPO in respect of the application for registration of the mark, a decision of his or her refusal to accept the registration of the mark in the Gambia. So, Honorable Speaker, here the issue is where it says shall have the same effect in the Gambia as the one registered under this act. So, and we don't know. Thank you.
Like Speaker said earlier, in some cases, maybe we just need to give you further clarification. And you are right, as lawmakers. The way these international registrations operate, when somebody wants to register something with WIPO in Geneva, before WIPO accepts it to apply to Gambia, they will send it to the Gambia. And the Gambia Registrar General will ensure that everything is in compliance with Gambian law and clears it. Or then they will be able to register it for it to have effect in the Gambia. So that's the way it operates.
The Registrar General communicates to WIPO in respect of the application for registration of the mark, a decision of his or her refusal to accept the mark, the registration of the mark in the Gambia. I think that's what you try to explain.
When we don't want it to apply, yeah.
Protocol, yeah.
Okay. Subclause 13. It says a mark registered by ARIPO in respect of which the Gambia has been designated by virtue of the Banjul Protocol on marks shall have the same effect in the Gambia as one registered under this act, except where the Registrar General communicates to ARIPO in respect of the application for registration of the mark, a decision of his or her refusal to accept the registration of the mark in the Gambia. So they are the same. It's the same.
It is, yes. You are dealing with a legal instrument. If you have any opinion, express it. It is proposed that Clause 60, examination, opposition, and registration of a mark stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 61, opposition proceedings and how brought before the court. How?
Opposition proceedings, semicolon. Okay. Honorable Attorney General. No more concerns? Okay, Honorable, we are just waiting for the heading.
Semicolon can go. Anything after the semicolon, we can eliminate it and it will still be okay. Yes. How those proceedings are commenced in the court. But if you say opposition proceedings include how you commence and whatever. So it's all inclusive. So yeah, we could do away with how brought before the court and just say opposition proceedings.
Opposition proceedings, how brought before the court, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 62, rights conferred by registration, duration and renewal.
It is, yes.
Okay. Honorable Speaker, if you compare clause 62.1 against 54.6, I just want clarity as to what is the difference between the two. 54.6 and clause 62.1. (52.1) and 54.6. Okay, I will read 62.1. Honorable Chair, 62.1 reads, owners of registered marks shall have the exclusive right to prevent any third party from making use, in the course of commercial operations, of identical or similar goods, similar signs for goods or services that are identical or related to those of which the mark has been registered, if such use would lead to confusion, unless with the prior consent of the owner and the Registrar General determines that there is no likelihood of confusion. That is 62.1. (54.6) reads, the owner of a proprietary industrial design shall have the right to prevent third parties not having the owner's consent from making, selling, or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. There, yes.
(54) is dealing with industrial design. 62 is dealing with trademarks. They are completely different topics. Remember, in this legislation, you'll see there are chapters. This bill is like a hybrid. It's bringing all intellectual property matters under one legislation. But they could be completely different industrial matter issues, topics. So the first one you read, 54, is dealing with industrial design. We are now on the trademark now. We are dealing with trademarks.
It's 60, for me, it's 62.1. And you know, in the first line, you're saying owners of registered marks shall have the exclusive right to 62.1. Owners of registered marks shall have the exclusive right to prevent any third party from making use in the course of commercial operations of identical or similar signs for goods and services that are identical or related to those of which the mark has been registered, if such use would lead to confusion unless with the prior consent of the owner. Now they come and add, and the Registrar General determines that there is no likelihood. So I'm saying if you say exclusive, and then now you come and say the registrar has some role to play there. So maybe we say a right. Shall have a right rather than exclusive right.
Somebody must be the arbiter to make a determination.
Honorable, your exclusive right is guaranteed. All right? Unless you give consent. Your exclusive right to your mark. This is a trademark. You have goods that you have trademarked already. So it's protected unless you give consent to anybody to use it. All right? But the Registrar General, in the event of a dispute, if, for example, you say this Apple phone is your trademark, you've trademarked it, and somebody made a phone that you claim is too similar to your Apple phone, therefore diluting your market, who do you go to? The complaint goes to the Registrar General. If the Registrar General proves that there is no likelihood of confusion, that is, the similarity that you are claiming doesn't exist, then that person will continue. If you are not happy with the decision of the Registrar General, then it goes to a tribunal. Eventually, it can go to a court. So this is in the event you claim that somebody's mark is too similar to yours and is causing confusion in the market. The Registrar General can say, no, you don't have a case. These marks are not similar in my professional opinion, so therefore there is no confusion in the minds of the consumers. If you disagree, then you challenge the registrar's decision. That's what it is saying here. That has nothing to do with your exclusive right. Your exclusive right is to your mark. But a situation where you are complaining somebody else is using something that is creating confusion between the consumers, among the consumers, then the registrar have a role to take a decision, whether you are right or not. Yeah.
It's not final. Yes?
Yes. Honorable Chair, I think with exclusivity, it should be in absolute terms. But allowing the Registrar General to make a determination would just serve as a clawback to that particular right. So I think I would go with him. Why not we say that shall have the right instead of saying exclusive right? Because the determination of the Auditor General is not only diluting it, but having it in the same clause is taking it back.
Let me attempt again to make a further clarification of this. Your right is exclusive. We cannot change that. If you have a mark, trademark, of whatever, let's use whatever, this is public hearing. I don't know whether I may end up being advertising for somebody. But think of any mark, any product that you have trademarked. Now, as long as you register it, nobody has the right to use that in commercial transaction or anything so similar that it will cause confusions in the eyes of the consumers. You see the problem? Now, that is exclusive. That cannot change. But if you allege that somebody's product is so similar to yours and is causing confusion, that's when the registrar has the right to say, okay, you are right, and if you are right, the registrar will authorize that other person to stop using those goods. But if you are wrong, in his professional view, he will tell you, I'm sorry, I don't think these things are too similar to cause confusion. He's not touching your exclusive right. He's just telling you that you are wrong. The other product that you are alleging is too similar or causing confusion with your goods. It's not correct. So he's saying your allegation is not correct. So you either agree with him and abandon the complaint, or you go beyond him now and pursue your rights. Because once you have registered your mark, you have the right to defend it even up to court level.
I think it's clear now. Yes, Honorable Member for Sani Mentre.
Chair, I just need clarity on the similarity of goods that the Honourable Minister is talking about. So in case there is similarity, which they've already confirmed that the other partner has to stop, producing that goods in market also. So the money has already been paid for that. Will he be giving back that money, or it will be null and void?
Usually you are asked the other person whose goods are infringing the trademark goods to withdraw from the market. Right? Yeah. So they are not allowed to continue to use that mark that is causing confusion. So if there are damages, if it goes to court, if it is sought out at register level, fine. But if it goes to court, yes, the court can award damages and make further orders.
Honorable nominated member Keba, Long Fofana.
Thank you for that explanation. It's clear, but I still have some doubts on, because we are talking about innovations and the innovations here. No, but okay, you can excuse my words. Now I would say it in general terms so that you would understand. The moment the possibility of confusing one thing to the other is present, which means still now, whether it is innovation, whether it is production, whether it is marks, it is coming from the human mind. So that's where I'm looking at the issue of exclusivity there. The possibility of confusing one thing to the other is already been made to an extent that someone needs to determine whether the claims are substantiated or not. So now the question is, the individual who is claimed to be the owner of that particular mark, whether he can claim exclusivity over it. That is my question. I would rather leave it as a right than saying exclusive right. Because it depends on someone else's determination. To him, that similarity is his product. So if you give him the exclusivity, then it is something else to me.
We talk about trademarks. Let's take an example. You have no proprietary right over water. Anybody can sell water. But you design your water bottle in such a way and named it in a particular way. That name, maybe you design your packaging in a particular way of design. That becomes your trademark. And you registered it so that all the bottles of waters in the market, people can identify this one belongs to Honorable, whatever. So that's your company, that's your mark. That mark is protected. So infringement would be, maybe if somebody knows that that mark is identified by consumers and maybe your water goes very fast because people identify it. And somebody wants his water also to market like yours. And he also try to copy your design to create confusion so that he can also sell as much as you are selling. Now, that is an infringement. So you said, look, no, this guy, my bottle is different from his bottle, but he decided to adapt my design, either my logo or my whatever, and put it on his. As a result, my consumers who are so addicted to my product cannot differentiate between my product and his product. So it's an infringement of my mark. Now, this is what we're talking about. Your exclusivity to use your mark is not an issue, and we cannot change that. You are only alleging that somebody is emulating your design. As a result, it's affecting your sales in the market because your consumers who are so loyal to your product now cannot distinguish your product from somebody else's product because of the confusion in the marks. All right? So because of that, you complain to the registrar. That's where we are saying it's not touching on your exclusive right to use your mark. The registrar is only saying, yes, you are right, therefore they will authorize the other person to desist. Or, no, you are wrong. These two are not similar. They are not creating confusion. That's all that this clause is addressing. It's not addressing the exclusive right. Exclusive right doesn't change. Your mark is yours, and once you register it, you have the exclusive right. That would not change. It's the confusion you are complaining, and that is what is being addressed. Whether truly there was confusion or there is no confusion.
Honorable Chair Salat. Honorable Chair Salat.
Yes. I think here the confusion with the nominated member, whether it's because of the word exclusive. But like, if you listen to the explanation of the Honorable Minister, because he said when your product is causing confusion by the consumers, not knowing who exactly owns this product, that's where you can report the matter. And then I think that is just self-explanatory. I think it's clear. When it's causing confusion, I don't know whether it belongs to Coca-Cola or it belongs to weak one. No, you don't understand. I think now the word exclusive right is where the confusion is.
Two, somebody say. But
No, Chair. Chair. I said this is a very good one. We leave it as it is. I mean, no, because
rights conferred by registration, duration, and renewal stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 62, no? Clause 63, limitation on rights conferred.
It is proposed that clause 63, limitation on rights conferred, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Honorable, I think we need to put a stop. We go and pray and you go and take your food. Because people cannot talk. Yes, you cannot talk. You are putting question, no answer. I am putting question, no answer. Something is happening. I think we go for lunch. If the lunch is not ready, you go and pray. After prayers, you go for your lunch. It is now, what's the time? 1:13, we come back 2:30. 3:30 rather. 3:30. We are coming back at 3:30. Sorry. Hey, in fact, let me go there. Okay. Sorry, I should just. But when we resume the assembly, we will discuss the time frame, and then we come back. Yes, but in Dantamuntole. Honorable. He said what?
Can I come in?
Yes, Chair. I say this one is a very good one. Our case with Noto Alliance will be very good for us to apply this one here. Our trademark with Noto Alliance will apply this one here.
Honorable members, we will now suspend the committee of the whole. Honorable members, when I put questions, you cannot talk, and now you can shout at the top of your voices. We will now suspend the committee of the whole House and resume this whole assembly. Honorable members, the House now resumes. Honorable members, it is 14:16. We go and have our lunch and pray, and we also give opportunity to the Honorable Minister. That will give them opportunity to tidy up the deferred clauses. Honorable Minister, that will give you time for you to deal with your deferred clauses. And then by the time we resume, we can look at them. So is 15:30 okay? The House is suspended until 15:30 sharp.